From the Library of Congress in Washington, D.C.
Good morning and welcome back. Thank you for attending day 2 of our Orphan Works and Mass Digitization Roundtables. We really had a very, I think, exciting and informative discussion yesterday, and we hope to continue the discussion today. I'll turn it over to Katie for the first panel.
Thank you for coming today. The first thing I want to do is, like yesterday, go around the room and say our names with our organization. So I will start with Ms. Hoffman.
Ann Hoffman, National Writers Union.
Elizabeth Townsend Guard, Tulane University.
Michael Weinberg, Public Knowledge.
Patrick Boyle on behalf of International Documentary Association and Film Independent.
Lee Knife from the Digital Media Association.
Mickey Ostreicher, National Press Photographers Association.
Maria Matthews, Professional Photographers of America.
Nancy Copans, Ithaca, which houses JSTOR, Portico, and Ithaca S&R.
Richard Burgess on behalf of A2IM.
Emily Feltrin, American Association of Law Libraries.
Jamie Love, Knowledge Ecology International.
Greg Cram, the New York Public Library.
Sally Shannon, ASJA, the American Society of Journalists and Authors.
Ariel Katz, University of Toronto, Faculty of Law.
Chuck Slocum, Writers Guild of America.
Jacqueline Charlesworth, U.S. Copyright Office.
I'm Katie Rowland, the Copyright Office, and
Karen Topol-Claggett.
Frank Muller, Copyright Office.
Thank you. So now we can begin. So this panel is about the different types of remedies that might be available if there was an orphan work scheme enacted into legislation. And as most of you, I assume all of you know, in the past versions of legislation, there were limitations. So it was not an exception. It was a limitation where there would be reasonable compensations and injunctive relief. And there have been, 5-6 years that have passed since that last legislation was talked about. So I thought it would be a good idea to talk about it again now. What has changed? What views might be on the different types of compensation, especially in light of the EU directive. And I wanted to open it up with a more of a broad question. I think we should probably split this into two different things, monetary and injunctive relief, so that we can kind of keep track of what's going on. And I thought we'd like to start with monetary relief. And last time, in the last legislation, there was this reasonable compensation model. And I wanted to go around and see if anyone had some general thoughts on that. They still think the reasonable compensation model is a good idea, and why not? Okay, Mr. Katz, and then Mr. Burgess.
I may just start with just a slightly more general observation, which it seems to me that the main reason why it has been so challenging to find a solution to the orphan work problem is because we tend to think about it only as a demand-side problem, right? Users need permission, but they try to get permission, but they don't get permission. They can't seek permission because there's nobody to get permission from. But, every demand-side problem also has a supply-side problem. And the reason why works becomes orphan is a supply-side problem. And the reason is that rationally for copyright owners, they may just let their work become orphan if they don't expect to have a future stream of revenue that would make it worth their while to maintain their works, maintain themselves locatable, because it is somewhat costly to do that. So if we think about the problem as a problem that sometimes owners may not have sufficient incentives to maintain themselves locatable, we can also start thinking of the solution from that perspective. And there are many areas of law that we have different sides that may contribute to a problem. For example, in tort law, right? There is the person who causes injury and there is the victim. But tort law often assigns liability or tweaks the remedies according to whom is the least cost avoider. Okay, so if there is a party that is better positioned to avoid a problem or minimize the incidence of the problem or the severity of the problem, the law may either put the entire liability on this party or allocate the liability. So again, in tort law you may be negligent and therefore liable, but if the other party could be contributor liable or comparative liable, and then you would have to pay less, even if you are the injurer. So I think when we think that copyright owners are often the least cost avoider of the problem, I think that's a reason why solving the problem from the remedy side is appropriate. And in general, I think courts should have, and I would argue they even have now, kind of their inherent power to tweak the remedies according to the situation, to take into the account the degree to which copyright owners maintain themselves locatable, and if they did not, that should affect the remedy, and that can be reduce the damages or injunctive relief, but it really depends on each particular case which remedy is the appropriate one.
Thank you, Mr. Katz. That reminds me of something that was discussed at our panel yesterday, where it was kind of the opposite range, where someone suggested that perhaps you would change the statutory damage range. It would be some sort of consideration whether or not a diligent search had been undertaken or not. So that's, I think, kind of goes along that range. Before we get into that specific, we'll come back to that. I wanted to get some more general thoughts as well. I think it was Mr. Burgess, Mr. Osterreicher, and Ms. Gard, and then Ms.
The consensus amongst A2IM members is that reasonable compensation is fine. I mean, we're in support of the idea of orphan works, but we also are users. We're users and creators. And we know that our members are very diligent in doing their searches to ascertain, whether something is, who the owners are, et cetera, and make sure we get clearances. At the same time, we're very often the victims of people who do not do diligent searches and who basically squat our works and use our works in unauthorized ways. We think that it's very important that we have easy injunctive relief, because we're small independent business owners, and if the costs are too great, we simply can't do it. And as far as we're concerned, an unaffordable right is no right at all. So not only do we want a reasonable compensation and easy injunctive relief, but we also believe that legal fees should be reimbursable. That we consider that to be absolutely important, because for a small business owner, hiring an attorney is a big deal.
Thank you, Mr. Burgess. Mr. Osterreicher?
I know yesterday we were talking about a number of things, and I expressed the creators' fears about how things would progress. I was really disappointed later on in the next couple of panels to constantly hear, well, we're going to rely on fair use. And if fair use doesn't work, we get a second bite at the apple, then we'd like orphan works. And we still don't really want us to slow anything down. So we really don't want to have much going on with orphan works, except for the fact that we would limit the remedies available to the creators. And one of our proposals, and I don't want to go into obviously everything that we've submitted in writing, but we certainly think that part of the orphan works, any orphan works legislation, should be tied to people being willing to participate in a small claims copyright board and have that adjudicated that way. And we certainly have a number of other recommendations, but really to level the playing field. This isn't just about speed. It's also about protecting the creators' rights. And I think that's something that we really need to keep in mind here, that should there be an orphan works legislation, that it's got to come with some safeguards that protect our sides as well. Because, from our perspective, there are, in terms of addressing, it's hard to locate. As I said yesterday, there are many photographers in particular who do everything they're supposed to do. They embed the metadata, they do everything, they register, and still at the end of the day, those images, which could have been created 5 minutes ago, could appear orphaned to somebody trying to locate who that person is, and for them to then suffer some more injustice in a way, to be still limited in their recovery, I think really does not create a balanced playing field.
Thank you, Mr. Osterreicher. I think Ms. Gard was next.
Let's go back to Ariel's comment on sort of a general broad thought. So Glenn Lenny and I ran a class, an Orphan Works class, where we studied the problem with 12 students pretty intensively, and then submitted a reply comment. So we read everything that's been written on Orphan Works. And what we ended up coming back to was the copyright law itself. And we thought that the copyright law itself had a lot of mechanisms in place that would, if we look at them, may help this problem. And we saw it as a three-prong approach. The first one is registration. We saw that the people who were saying there was no orphan work problem had registered their works. Those that thought there was an orphan work problem were not registering their works, were saying they were not registering their works. And so we started to look at what registration was. And registration in our system is the sort of the key component of the system. So each system we've had from the beginning had a moment of sort of a triggering effect. So 1790, title registration, deposit, notice, as you go, and registration is that for this system. So when you register a work, it tells the world that you actually care about the work and you're going to protect the work, you get statutory damages, attorney's fees. We think that, and Kyle Courtney said, well, if it was registered, we wouldn't think it was an orphan work. So we think starting with registration as the key component of the system would let the world know that it is not orphan. That's the first part. Second is recordation. We heard from the Directors Guild that there were other rights that people didn't know about. And so we think that if you have a right, let the Copyright Office know, record it so that the world knows. And that if everyone knows what the rights are and who you are, that it's easier for people to find you. And that the Copyright Office is the place to do that. And then the third part is release. So we always talk about orphans, but oftentimes I think that they're more lost boys. So they never grow up. And so one of the problems is that our system is based on a Life Plus system, and so is most of the world. I work on a project that we look at every copyright law in the world. We need a system that if there's no known authorship, if you don't know who the author is, that then you go to a burn minimum standard, which is not known, so 50 years from creation, and if not, and then if there's publication, 50 years from publication. That allows for you 50 years to find the author. And if in that time you find it, it goes to Life Plus 50, Life Plus 70, or whatever the system is. It's a very standard system around the world, but it allows the orphans to grow up, to be emancipated, to at some point no longer be orphans. And so we think that's an important component of the system. So that I just wanted to sort of put that out there to start with the copyright law itself. If the metadata is stripped, that we already have stuff in the Copyright Act that tells you if someone removes there's penalties. If they're too little, they're very minor penalties. They can really big. But start with what we have and build from there because it's a good system and there's a lot of thought put into it already.
Thank you, Ms. Gard. I think that touches on many things that are a little bit beyond the scope of this panel, and just copyright law in general and formalities, but obviously a lot of people have argued that the lack of formalities are what has caused some of these orphan works problems in the past, but we have acceded to the Berne Convention, so we are a little bit.
Wait, I just want to clarify. I wasn't arguing for formalities at all. Just using the system we actually have, there's no need for going back to a formality system in any way. So
Encouraging voluntary use of the registration system.
Exactly.
More voluntary, and perhaps incorporating some of the things that we talked about yesterday in terms of making that system better and easier and more efficient for photographers and others to be able to use.
Yeah.
Okay, thank you. Now I think Ms. Kogans was next.
Yeah, hi. I think while injunctive relief and reasonable compensation without statutory damages feels like a reasonable compromise, I mean, people could disagree about many aspects of that. I want to just point out what that might feel like for a user and ways in which it also still poses problems. I don't have a solution here, but I want to talk about the thought process. If you're a not-for-profit library or museum looking to digitize a collection, that takes time, money, effort. These are precious resources. If there's still a risk of takedown and removal, that's significant. It's not as significant as statutory damages, but it still may weigh in favor of not making that available because there's a lot of other content to get through too. So depending on what the goals are here, if there's sort of some sort of public benefit to making certain materials available, even takedown and reasonable compensation might weigh against the decision to digitize.
Okay, Mr. Graham.
And before you begin, I will have a follow-up, I guess, to you and anyone else who wants to respond. We touched on this a little bit yesterday in terms of there were, in previous bills, in the 2008 bill, specific provisions on the limitation on remedies for nonprofit educational institutions who were operating without a direct or indirect commercial advantage. So that might be a way to address some of the concerns that you raised, and if anybody wants to respond to that, that would be helpful as well.
The type of user question that we started with yesterday, but you all of you were not on that panel. I see you guys. So the next person was Mr. Cram, and then Mr. Love, and then Ms. Shannon, and Mr. Slocum, and then Mr. Katzkin.
So I wanted to follow up with what Karen just said. So the New York Public Library does not enjoy sovereign immunity. We are subject to monetary damages, and that weighs heavily on our decisions to use collections. But let me tell you about a collection that we did digitize that we feel are orphans. This collection is the 1939-1940 World's Fair. We have the corporate records that came from the fair, and it's some 2,500 boxes of material, including 12,000 photographs. Looking at the material, it's a heavily used collection in part because it reflects the time of the 39 and 40 World's Fair. It reflects attitudes at the fair, reflects what the exhibitions were. It's a really valuable collection, and we realized quickly that our users would benefit from it from being digitized and put online. So there's about 12,000 promotional photographs in the collection. The good thing about having the corporate records is we were able to conduct a search. I spent 2 days in our archive looking through the corporate records, trying to find any kind of assignments, any kind of copyright transfers, anything before the corporation dissolved, and I found nothing. So we did a search then on Google and on the Copyright Office's records to try to find a rights holder, and we couldn't find a rights holder. So looking at the worst case scenario, our digitization of that material and putting it online would result in a maximum statutory damage in the worst case scenario of $1.8 billion. That would devastate the library. $1.8 billion would cost us services, it would hurt the public that relies on us, and we just couldn't afford it. But we still thought that it was a valuable collection, so we ended up digitizing it. We made it part of an application, an app on the iTunes. We made that app available for free, and that app ended up being the educational app, one of the educational apps of the year for the year that we put it out. So we thought that use was protected by fair use, but we were also concerned, if an Orphan Works legislation goes forward, which we don't think it needs to, but if it does, we really are concerned about a limitation on remedies. We are conscientious users. We certainly did our homework in this case, and we were really concerned about having facing statutory damages even after an orphan's search has been conducted.
So when we talk about reasonable compensation, you think that would not include the current statutory damages scheme?
That's right. $1.8 billion would not work for us.
And just to follow up on that as well, so if from your perspective then, reasonable compensation at all might be a problem, not even outside of the statutory damages, but you would prefer a provision like we had in the previous bills where if it was done for nonprofit educational purposes, without a direct or indirect commercial advantage, then that provision would be helpful for you
I think
as
so.
well.
The language at the end is a little tricky. I think everyone's identified that language is tricky, but yes, I think that would be really helpful for us. I mean, the whole goal here, I think, is to encourage productive uses of orphan works, and having a damages penalty, a monetary damages penalty hanging over us is not going to encourage us to use this, so you're not going to get the works out that maybe the goal of the legislation is to do.
Thank you, Mr. Cram. And I think Mr. Love was next, and then we'll go around.
Thank you very much. In my job, I have to write a lot, and I write book chapters, articles, and things. I remember one time I was trying to get a book chapter that I wrote copied, and the place I took it to wouldn't do it because they thought maybe I didn't have permission to do it. I said, well, I'm the author, and they weren't impressed with that. And so I had to then contact the publisher. The publisher really, it was kind of an awkward situation because the only way you can prove that you're owner is if you establish, just being the author, you can't prove that you're the only thing because they just assume that there might be some fugitive document that says that you're not the owner. And it's kind of the burden's on you to prove that it doesn't exist, which is kind of a difficult thing to do. I found that over the period of time, I have no idea who the right owners are on almost everything I've written, and I'm old enough to have written quite a few things over the years. And so it's just, I think, it's just as a practical problem, it's one thing to find out who the publisher or who the author is. It's another thing to figure out who the hell owns the rights to the thing. And for most things that are not, people are not being currently commercially exploited, the reality is nobody has an incentive to keep records, to figure it out, to search, to find that stuff, and they're just not very helpful when you ask them to do that. That's been my experience. Now, I would just put that out there. So I think that that's part of the problem. Now, I think that the remedies that people have, it's interesting that the Berne, you mentioned the Berne Convention yourself, as sort of a reason why we can't talk about formalities. But the Berne, I will say, says nothing about remedies, and so, or almost nothing about remedies. It says nothing about compensation. I mean, except in, well, in the exceptions it does, but for infringement, it's really kind of a blank slate. So I think there's a lot of flexibility there. Usually the trade agreements are where you really run into the issues about the standards and the norms for both injunctions and for damages. And so it's weird for us to, we should be able to at this meeting talk about the trade agreements because those are the real contours of public policy that we have to work around in fashioning legislation. And in terms of this thing about the formalities about the Berne does not apply to related rights. Now, the United States, we're not familiar with the related rights concepts. We just call everything copyright. But the Berne doesn't apply to everything we call copyright. So if a singer performs a song, if there's other types of things that are in Europe would be called related rights in other countries, those things aren't controlled by the Berne anyhow. And in fact, there's nothing in the Rome Convention, for example, on formalities. That sort of pops up later in some of these later treaties, which are, by the way, not subject to dispute resolution in multilateral treaties at this point, although we're cramming them into dispute resolution in free trade agreements hand over, as fast as we can. So I think that to the extent that you're going to solve it's a rights and responsibilities. I think if the copyright owner wants the government to come in and issue injunctions and big fines and things like that, fine. But then they should have a responsibility to make the system work. So I think that to the extent that people don't participate or the photographers don't sort of work harder to kind of create like the right kinds of systems that make it easier to verify ownership, and other types of publishers and things like that too, where you can kind of sort things out. It should not be easy to get an injunction if you can't prove that you're the right owner, or that it would have been almost impossible for everyone to figure out who the right owner is. And the same thing on really aggressive forms of damages. I think that yesterday I talked a little bit about the fact that the ACTA agreement and the TPP are changing international norms in a very aggressive way on damages. And that's a problem, and that hasn't happened with the TPP. But once it does, it will be subject to dispute resolution by private parties under the investor-state provisions of those agreements. And the state sovereign immunity issue, which is a safeguard for a lot of people, just is not included as a possibility under the TPP agreement. What we're doing is USTR is basically creating a situation where the U.S. government's going to be fined large amounts of money for having sovereign immunity. I mean, it's basically, it's illegal under the agreement. It's subject to fines, not by our court system, but by private arbitrators, with very effective, as we're learning with some of the WTO disputes, ways of retaliating through the agreements. And so I think you've got major challenges in dealing with the damages and the formalities issues, not because of the multilateral agreements, but because of the trade agreements that you're negotiating, which are done in a secretive fashion, behind closed doors, without publishing the text, without these kind of meetings, without any opportunity to see what the hell's going on. So I think that it's good that you're having this meeting, and you should encourage USTR to open up its process a bit so we can see what they're doing to undermine what you're trying to do here today.
Thank you, Mr. Love. I would like to, I'm going to call on the rest of the people in turn, but I would like to really focus on the reasonable compensation part of this so that we can talk about that a little bit more, being that that's the theme of this panel. I think Ms. Shannon was next.
Thank you. I represent the wire walkers, the riders who work without a net, the riders who have no salary, no university salary particularly to fall back on, so we're very different from academic writers. We make our living from what we write, and most of us don't know where the rent will come from in 3 months. Any person who lives by their endeavors in one of the arts is in this situation. So we're very aware when our incomes are threatened, and they have been in multiple ways in the last decade or so. One of the things that we see that would be very helpful and would prevent a lot of offerings would be to change Section 203 so that rights automatically revert to authors when a publisher goes out of business. Right now, there are a lot of writers who are left in injunctive limbo because you can't determine who actually owns the rights, and it is very difficult. I agree with Mickey on that it is very difficult to determine the rights. One of the three tests of confirming who owns the rights is the adjudication process. And we're already out of conformity with Byrne in that we have no easy process for injunctive relief. You can't get any more formal than having to take someone to court. And if you're a person who makes $50,000 or $60,000 a year, the prospect of going up against a publisher or a large corporation is just about as formal a formality as you can get. In fact, it's impossible. So some sort of injunctive relief would be very helpful for us. But I want to say that we're also a little bit alarmed, even as I say that, because when you name an amount for a particular piece of writing, that amount very often becomes the ceiling for which a writer will be paid for that kind of work. And aren't we, in some ways, if that happens, running afoul of rate-setting injunctions? I mean, if we set a rate for a particular kind of work for compensation, how is that different from a problem with antitrust? I just throw that out there because very often when you do talk about a rate for a particular piece of work, you run into that rate-setting problem.
I would just, follow up and we can have others respond in terms of the reasonable compensation. It would kind of be a general standard that would be set forth in the statute, and then the court would have to assess what would be reasonable compensation under the circumstances of the use in that particular case. And I think in our 2006 report, we noted that there might be instances, for example, where reasonable compensation could be high, or sometimes actually where reasonable compensation might be considered to be very low or even zero if the court was able to establish that the type of use was the kind of use that someone might have just given on a royalty-free basis. So it would depend based on the case in front of the court.
Thank you, that's helpful. I just want to say one last thing, and that is in response to Elizabeth's very thoughtful comments. If we make registering copyright more difficult, we come very close to blaming the victim when there's an issue. And I worry about that, about tightening up the rules for copyright.
Thank you.
I can respond probably for what Elizabeth was probably going to say, which is saying that she doesn't want to make registration more difficult. She actually wants to make it easier to encourage more people to actually use the process.
Okay. And that you get without registering, you don't get statutory damages, you don't get attorney's fees. Right now.
Then we should have automatic registration.
That's right.
A presumption of registration.
That's right. Well, you can't. You have to.
Yes, I know.
You have to actually register the work.
Yes, I know what we have now, but I think having to go online and pay that $35 fee and go through that is intimidating. It's intimidating. Now, all of you in this room find it a very easy thing to do, but I tell you that people who are creators don't find it a very easy thing to do.
Understood. And we have a lot of people, thank you, so I'm going to keep going around, but understood. I think the problems with registration, we're very aware of here at the Copyright Office, and we obviously always are looking into that issue. Mr. Slocum.
Yeah, I think one of the key details that's going to have to be worked out here is the level of granularity of the various policies. I tend to see the solutions more in terms of the uses being made rather than remedies or whatever being variable based on who the user is. And also, as I mentioned before, that there's a lot of granularity to what rights might be orphaned and other rights not orphaned. And then I think the other thing is that the type of work or the regime under which works are created is going to be very relevant. Our works are created, they're required to be works for hire under the law. And in that context, there's a very rich and broad sense of what the right compensation is for the actual creators. In our sense, residuals that are set up, that are established for the industry. And as is contemplated a little bit in the DMCA, with regard to people that buy film libraries out of bankruptcy, they have to honor those residuals. If there's a database where they can check at our websites and whatnot, I think that would be a good thing for the policy to do, is look for established solutions to the problems that are relevant to the very specific criteria, very specific situation of certain works. So I think there are going to be a lot of solutions out there in the marketplace that have already solved the problem of what's reasonable compensation. No need to reinvent.
Thank you, Mr. Slocum. I think Mr. Katz was next.
Yeah, I think a bit related to Mr. Slocum's comment. Listening to a lot of some of the discussion yesterday, main difficulty arises because we tend also to think about the orphan works as a status question, right? We try to define what an orphan work is, and okay, so what are the prerequisites? What it qualifies to be an orphan? And then that raises a lot of anxieties. Okay, so authors are anxious about false positive, right? What happens if my work is designated as an orphan where it shouldn't be? And they're very concerned about that. And users are also concerned about false negative, right? What if I did a lot of diligent search, but just the last, database that exists somewhere, I did not consult that one, and bam, now I'm subject to the whole array of damages. And instead, I think, again, we should think about it not as a status question, but as a continuum. So the question whether a work is orphan is not something in an abstract. It is with respect to a particular use. What are the requirements for that particular use? And that depends, okay, what the use is, and what kind of work is. What are the technologies that are available for registration, for recordation, for search, and all those things are very fluid and dynamic and very context specific. And that should reflect also on the damages, on the remedies. So for some type of uses or users, limiting damages and saying only injunctive relief, okay, if you're a nonprofit and all you can get, okay, an order, stop doing what you're doing or pull the work out, is fine. There isn't big risk in that. In some other type of projects, injunctive relief is a disaster, and you would be happy to pay damages, but you think about, there's somewhere here, I'm sure today there are debates about, in the patents setting, about injunctive relief and standard setting organization and all the problems that arise from injunctive relief. So again, it really has to be very case specific, depending on the use. Are there sunk costs that very, very difficult to pull out, or could you easily do that? If you easily do that, injunctive relief is great. Otherwise, it's a disaster.
I think I see Ms. Hoffman. I think at this point, we can veering into the injunctive relief arena. So if anyone has comments on the injunctive relief issues as well, basically, should there be injunctive relief? Should everybody be subject to injunctive relief? Should it be different for different types of works? For example, a derivative work like a film, or maybe there's a clip inserted into a documentary. How does that work? That kind of thing. So if you have discussions about the reasonable compensation, that would be great. But also, if we're going to open it up to the injunctive relief as well now, I think I have Ms. Matthews, then Mr. Weinberg, then Mr. Knife, Mr. Burgess, Mr. Hoffman, Ms. Hoffman, and then Mr. Love. So, Ms. Matthews.
For our members as professional photographers, the vast majority of whom are portrait and wedding folks, they shoot about 1,000 images a week easily, especially folks who are doing weddings. The burden of going through the registration process for them is insurmountable. I mean, they're, for the most part, 1 to 3 person studios who are all out shooting what at the end of a calendar year could amount to 20,000 images. For them to catalog and put into even one of the informal registries that we create as part of just a diligent search, it is insurmountable, much less register with the Copyright Office. So for them, making reasonable compensation available if something's orphaned, once that diligent search has been completed, if they are not found, is key. What that reasonable compensation is could be left to the marketplace. Most photographers who are in this direct-to-consumer market themselves have licensing fees no different than somebody who's in an advertorial or editorial field. They license images for Facebook and Instagram for the clients to go off and make their own prints, knowing that they'll lose revenue by handing over those image files, and potentially the prospect that they'll be manipulated by the client and inadvertently orphaned. Secondly, we believe that the creator should be able to obtain that compensation, that for them it shouldn't result in a lawsuit, that there should be some alternative process like the small claims court that you are currently exploring, and that the amount that they receive be a reasonable royalty, some token for that use that they might have otherwise licensed had they been in a legitimate user copyright owner relationship.
I have a follow-up question for you on that. You seem to be more focused on the monetary damages than the injunctive relief. How would you feel about the injunctive relief part of the remedies?
For us, it really depends on the origin of the image. In some instances, it may be easily removable. It may be something that needs to come off a website or out of circulation. In other instances, that the inability to cease use should be directly tied back to monetary compensation.
Okay.
And I just had one quick follow-up as well. And it sounds as if, I guess, and I think this is something that Mickey had mentioned as well, the comfort level that you all would have with respect to the limitations on remedies and the monetary damages portion, limiting it to reasonable compensation is directly tied to the small claims aspect, because even having that broadly available in federal court is a difficult obstacle for you. So you support it, but support it in conjunction with the small claims type solution.
Because even that reasonable licensing fee that they were to negotiate is not necessarily going to outweigh the legal fees that they're going to have to expend.
Thank you, Ms. Matthews. Mr. Weinberg?
I just want to make a sort of larger point about thinking about the role of remedies in this whole debate. I think that when we think about remedies, there's a temptation to bring in a lot of other issues as well, and I would urge you to really focus on structuring a remedies system that is a remedy for the problem that is the focus of this proceeding, which is an orphan work. There's someone who undergoes a search, they cannot find the owner, they make use of it, and then the owner appears, however. What is the right way to deal with that? There's a temptation when at a round table like this or any proceeding, there's a representation of people, of creators who are often not going to be orphans in a correctly structured system. And a temptation to structure the remedies to avoid the false positives, the false negatives that Professor Katz was talking about. If you're worried about the false positives and the false negatives, the remedies isn't necessarily the place to fix that. Right? If you're worried about this being used as a way to set a floor for legitimate market payments by people who are operating in the market in a nefarious way, creating remedies that are so scary to prevent that is not necessarily the most efficient way to deal with that. Instead, think about how we define a diligent search as a way to deal with that. If there are problems with the registration system, if by chance there are problems with the registration system that make it hard for people to register, creating punishing damages is not necessarily the right solution for that, because having these orphan works out there does create a real, although very diffuse, cost on society. And so creating remedies that are so punitive that you need, even the New York Public Library is afraid to use them because of fear of use, creates a massive drag that is hard to represent in a place like this, but is actually, hopefully, if you correctly structure this system, will be the vast majority of the users, the kind of unknown users on both sides, both the creators and the users. And so there's this temptation to focus on what will hopefully be extremely fringe cases, but allowing that to drive all the balancing will result in a system that may be useless to everyone.
I have a follow-up question for you. So assume that we have this perfect diligent search requirement, and we all know exactly, and everyone's registering and whatnot. If there was an orphan under that scenario, what would you think the reasonable compensation or injunctive relief options should be?
Yeah, I mean, I think that turns on the uses, because the uses are many and the users are many. And I think we run into problems with copyrights and we try a one-size-fits-all solution. I think that's one of the answers that we've seen with the statutory damages. And so it's important to set up a process that really focuses on the reasonableness of the compensation. And that's just going to vary. And there's no way to draft around the fact that the reasonableness of damages for a script that gets turned into a multi-billion-dollar movie is different than the reasonableness of someone who uses their wedding photos on Facebook without authorization.
And I had one kind of follow-up, because I think that was generally the way that the bill was structured before in 2008, but just following up on something Ariel said before in terms of, I guess, assigning some type of responsibility on both ends. Are you suggesting, or were you suggesting that somehow the concept of reasonable compensation should take into account, for example, whether a copyright owner registered, whether they were, doing something to, ensure that they could be found, as opposed to just the standard that we had in 2008, which was really just a kind of a willing buyer, willing seller type standard?
Yeah, I mean, I thought that was a very attractive idea when I heard it earlier, and I think I appreciate that registration imposes a burden. But we are talking about a commercial market here, right? Buying a camera or buying a word processing software also imposes a burden. And I don't want to be flippant about that and say that any burden is legitimate because they are commercial operators. But you get a lot of benefits in copyright. And society expecting creators to do some sort of action to take full advantage of that does not strike me as unreasonable, especially because we've seen that the cost of not doing that is to create this giant pool of works that are just locked away.
And this is my last follow-up, just going on this
Keep following up, I'm happy to talk.
This is just because this is kind of a new concept. I know it's in some comments, but one of the things we are focusing on is kind of should we just do the 2008 bill, or should we add tweaks to it? And this would certainly be a tweak. So would this be along the lines of something, for example, a provision that said in certain circumstances, the court in its discretion could reduce the reasonable compensation depending on whether the work was registered, whether it was recorded appropriately in the Copyright Office, and/or other factors, or something along that
I mean, I think you build that into the reasonableness of the compensation, right? Part of that calculation, whether explicitly or implicitly, it may be, how much work the rights holder has done to make themselves findable. If they've done a lot of work to make themselves findable, and the user has said, oh well, but we couldn't find it. Then maybe it is more reasonable to compensate the creator than it is if they have not done that.
I will point out, on the flip side, if you're going to have a reduction in damages due to not registering your work or whatnot, it might be fair to have an increase in damages for someone who claims that they've done a good faith search when in fact they just punched into Google and that was their only attempt at finding it.
Yeah, I mean, and I think that is a great way to protect against a lot of the concerns that people at this table have of the system being abused, because we organizations, public knowledge, think that it's very important to give people a way to access orphan works. We do not think that we should create an orphan works system that in fact allows people to take advantage of creators and say that it was orphan works. So, like all things in copyright, it is a balance, but it is a legitimate thing to say that some searches are real and some searches are not, and if you don't do a real search, you don't get all of the advantages of the orphan works system, whatever it may be.
And in fact, you might get, if you were kicked out of orphans, you might get a higher statutory range.
Right, but because as long as there's an actual functioning orphan work system for good faith actors.
Thank you, Mr. Weinberg. So I'll go down the list of who we have, just so you don't need to keep raising your hands. We have Mr. Knife, Mr. Burgess, Ms. Hoffman, Mr. Boyle, Mr. Love, Ms. Gard, and Ms. Kogan. So we're going to start with Mr. Knife.
Oh, I feel like I've been waiting about 6 days to speak, largely because that exchange kind of presaged exactly what I've been waiting to say for a while, which is, well, first of all, I want to reflect on what was actually just said there. I think using words like reduce or increase is exactly what we don't want to do, including, using words like statutory damages. I think we should continue to focus on the idea of reasonable compensation. I think it's just, it's anathema to the idea of what we're trying to do here, which is, I think, ostensibly something, ethical and reasonable, to start talking about, well, you get less, you get more. I don't think it should be talked about that way. But moving off of that, the point I was going to make was something that was touched on here in the exchange, which is if we're, and this goes to both reasonable compensation and also the potential of injunctive relief, that if we should examine everything. We shouldn't just examine whether or not the use was commercial, whether or not it was done by a public or a private entity. We have to look at a whole spectrum of things to the point of it being very, very granular. We should look at the type of user, the type of use, the way the work was created, the behavior of the copyright owner and or author. You have to look at all of those things to determine what reasonable compensation is, or whether or not there should be injunctive relief. And that includes, as you talked about, moving into the injunctive relief question, whether or not it's maybe a small piece of a work that is embodied in a larger, either transformative or a subsequent work. All of those things have to be considered, and that's a difficult process. And in closing, I would just say, and I apologize if I'm touching on something that is going afield of what you want to talk about here this morning, but that raises concerns about whether or not all of this can be handled in a very fast-moving, low-cost, small claims type of environment. Everything that we're talking about here, just as copyright is in general, is very, very nuanced, very, very complicated, very, very important for all the parties involved, and has grown up over hundreds of years of legislation, very, very considered legislation and judicial process. I'm not sure that any of this can be kind of crammed down into an easy to get into, easy to get out of, low-cost resolution. As attractive as that may seem as a concept on first blush, I think when you think about it and you consider all of the concerns that we really have to address here, it becomes less attractive, the idea of having some kind of fast lane small claims resolution.
Thank you, Mr. Knife, and I will continue to go around. People have already requested to speak, to talk about things we're talking about, but the issue of small claims keeps popping up. I was going to address it towards the end, but if you have something you want to say before I move along to that aspect, that's fine too. As you know, the Copyright Office has issued a report on small claims recommending a small claims tribunal within the Copyright Office. We are big proponents of that, and we were hoping that we could talk about that as well. It got its genesis in the Orphan Works discussions back in the early 2000s, and we revisited it more broadly. So not just for Orphan Works, but for other works of a smaller economic value. And we believe that it would be a good place to do some of this work, which would also make it easier for everyone to get an easy, fast, less expensive resolution. So I definitely intend to talk about that towards the end, but if you wanted to say something now, that would be great too. Mr. Burgess.
I wanted to say that A2IM members are certainly not in favor of creating any system that's onerous for anybody, and we're actually not in favor of punitive statutory damages unless somebody is a mass continual infringer or somebody encourages other people to infringe, other users to infringe. Having said that, I think the idea of shifting any level of responsibility off onto the creator would be incredibly counterproductive, because certainly from the individual creators, freelance writers and musicians and so on and so forth, that would be absolutely impossible, because they have difficulty with the registration process as it is, and frankly, even at the modest price that registration is right now, that's more than a lot of artists can afford. Likewise with our small business community. So although registration in many ways makes sense, I know that we've been hearing rumors, talk of the price going up, perhaps doubling, I think any move in that direction would be bad. If there's any way to improve, to streamline the process, make it easier, make it simpler for creators, and also if there's any way to reduce the price, I think that would be a good thing. But I do think, and I think several people have said this already, that you can't consider any of these in isolation. So the way I see it is there's rules, tools, and remedies. And I think, you know, we're very opposed, HYM is very opposed to the idea of, you know, just extending fair use, because already there's utter confusion out there in terms of what is fair use and what defines fair use. So it seems like having extremely clear rules as to what is a reasonably diligent search is really important. And then the tools with which to do it, so databases, approved databases, whatever, in order to be able to do it. And then the remedies, because unfortunately there are bad actors out there, and we're subject to this all the time. This is not just some, you know, fantasy. People are just using our works without authorization, without even bothering to contact anybody. And I also have to say, in terms of shifting responsibility back onto creators, in the world we live in today, with Google and all the search tools we have, it's not that difficult to find people. And I think registration, if everything was registered with the Copyright Office, that'd be a wonderful thing, as long as we could make it doable for independent artists and small labels like A2IM represents. Thank you.
Thank you, Mr. Burgess. Ms. Hoffman.
I think the whole tone is putting the burden on the wrong party, blaming the victim plus. Somebody wants to use an orphan work. They know who they are. They should be the party required to register and to say, here's what we want to use this work. Does anybody claim it? And they ought to be required to publish that for a period of time and give people an opportunity to come forward. And the Hafi Trust, again, very responsible group doing what they thought was a very responsible job, and they had to stop it because it was totally irresponsible. But the way they found that out was by publishing it, by publishing, this is what we intend to call Orphan. And I think if that became the way things operated, a lot of these problems would be eliminated.
Would you fold that into the remedies, or would you fold that into just the general orphan works?
General
What is an
orphan
orphan
works. We are creating, in effect, a new category of work. Let's require people who say they are using it to register.
Like an intent to use.
Yeah.
That has been considered in the past.
Thank you, Ms. Hoffman. Mr. Boyle?
Okay, back to remedies more. From the perspective of creators, we believe that rights holders should be allowed to recover reasonable royalties. We support a legislative solution that limits injunctions and statutory damages if the creators have done a reasonably diligent search. If we don't limit those type of remedies for people who have done a reasonably diligent search, no one is going to use this solution. It won't work because people will still be subject to an injunction that can destroy an entire project at any stage of the project, no matter how much money and time they've put into it. And no one is going to sign up for that kind of solution. A safe harbor for those who perform a reasonably diligent search encourages people to do such searches. Reasonably diligent searches will lead to the discovery of owners, increase licensing opportunities, and reduce the amount of orphan works, all of which are goals of pretty much everyone here as far as I can tell. Injunctions and statutory damages are a powerful stick, but they don't always work. We're trying to provide a carrot to get people to do a search who are otherwise too afraid to do so because of the penalties associated with a failed search or the consequences of such. There are many filmmakers who want to use material, would pay for to use that material, but they're too afraid to begin the search to get that material. Something I wanted to say is I agree with what Mr. Weinberg said, and it's important to remember what we're actually talking about here. We're not talking about infringers. Infringers are still subject to the full weight of traditional copyright remedies. We're talking about people who want to use orphan works. And we want to enable to people who want to do the right thing to do the right thing. And the way to do that is by limiting remedies so people can do reasonably diligent searches.
Thank you, Mr. Boyle. I had a follow-up question for you. Seeing that you work in the with films, how do you feel about injunctive relief for films? So, for example, a sound recording is in the film or something else that might be incorporated into film. How would you think injunctive relief would work with that?
So yeah, that's the problem right there. A film can be composed of 1,000 different copyright works, or more than that. But an injunction can stop an entire project for one potentially infringing copyright work. And it's even more important to remember that it's not the injunction itself that's really the problem, it's the threat of injunction. As we've seen with patents, people can threaten injunctions and stop things before they even get started because it's too hard to fight those litigation costs. It's easier to settle outside of court, and that hold-up power is something that we have to be caution against.
And one follow-up, just to tweak that a little bit, or follow up with a question on that a little bit. So I understand that you do want to prevent injunctions for kind of transformative works, or works that have been created, or derivative works that have been created, rather. But what about injunctive relief for works that have not kind of been turned into a new work? Just allowing injunctive relief if you just took a photograph, for example, and have posted that photograph, but not used it in any other type of work.
Something that we think is, and it was in the 2008 bill, is judicial discretion is very important in this regard. Reasonable compensation is something that's important. So if something, and you balance the hardships, that's the case in all injunctions after eBay. So something shutting down an entire film is very different than somebody taking a picture off the internet.
Thank you. To follow up with that, and this is really more for the content owners, all the content owners, which is, it seems that there is more of an interest in the reasonable compensation than the injunctive relief in most cases, at least from what we're hearing around the table. And I just wanted to kind of do a quick aside and poll the panel on that. Does anyone have anything very quick to say about their preference for injunctive relief versus monetary relief? Yes, Mr. Smith.
I think when it comes to sort of the actual distribution of a whole work, especially if it's a substantial work, like republishing a book or putting a movie out on a DVD, that in those situations, injunctive relief might be much more appropriate because it's the entire economic viability of the original product. If it was incorrectly identified as an orphan work, that'd be much more significant than a clip that's incorporated into a 2-hour movie.
So it would depend to you on the type of, if it was the screenplay versus just a sound recording that was in the background of one scene or something.
Unfortunately, there are a lot of factors. It's how much does the use under the orphan permission overtake the market viability of the product? Was it easily findable as an orphan work? How much of a diligent search? All the factors need to come into play, I think.
Does anyone else have it? Ms. Agard, and then Ms. Shannon.
I think also 512C is a really great model, that you see that I'm the copyright holder, that's my work, take it down, it happens quick, it doesn't cost a lot. I think it's a really good solution. It's injunctive-like, but you're not having to go to the courts, you're not having to register, you're not having to do anything of those sorts of things, and that should be something to consider in terms of orphan works. It's a quick, fast, easy way to get some relief.
Anyone else want to speak to the injunctive relief versus Ms. Shannon?
In our case, it would be some of both, but I think it would depend on the magnitude of the project. If we had to choose, I think it would be injunctive relief over monetary relief.
Can you explain why?
I'm sorry?
Can you expound on that? Explain.
Yes. If, for example, there was a dispute about the rights for an entire book, and an author wanted a book that was out of print, and there was a dispute with the publisher about who owned the rights, and the author wanted to take a chapter of that book and turn it into a pamphlet and sell it on the internet, and that's what was in play here, a dollar sale pamphlet, then I think a small claim might be appropriate. If it was a much bigger project that was at stake, then injunctive relief, I think, would be more appropriate.
Okay. Thank you, Ms. Shannon. Going back to my pre-existing list of people who wanted to speak, I think Mr. Love was next.
Thank you. I mean, one thing on damages, I mean, we think I assume that if a work remains an orphan work, the damages are zero for use. And so you're really talking about a work that starts out being perceived as an orphan, and somebody shows up and says, hey, wait a second, that's mine, right? That's the kind of cases you're talking about. I think that in the patent area, there's a couple lessons you might kind of look at to see how things are playing out. You've got people mentioned about the problem of wordsmithing on the criteria. The Georgia Smith, the 15-factor Georgia Pacific standard for patent things is just an example of probably where you don't want to go. I mean, it's got like a whole wide range of things that you have to consider when you look at a patent, and almost nobody can really do a real good expert's job of actually following everything. It's just, it says, because it says everything, it says almost nothing in a way. So I think that in some ways keeping it fairly simple is probably a good idea, and trying to figure out what you're trying to accomplish, and leaving it up to some discretion. I would suggest some language, because we're interested in expanding access to works, orphan works, and we don't want to discourage people from exploiting and creating new opportunities to have, because we think we're like losing a whole huge amount of our culture right now because of people are afraid to do anything with orphan works. And I would say in determining damages, a court may take into consideration the extent to which the work was earlier exploited commercially and the period of time since the work was exploited commercially. Too many ands in here. And the public interest in inducing investments in activities that expand access to orphaned works. So I had these three issues. One, was the work ever perceived to be a commercial work? Because I think a lot of people in the table here, they represent people that are professionals, that are, they've got things that they're trying to make money of. I think those things deserve to have a little bit different status than things where people, it's, the family wedding pictures or something like that. I think that's sort of, in my mind, those are different equities. Secondly, the period of time. I mean, if something has been, like it's 2 or 3 years since it was, it was commercial, I can understand why I'd be pretty angry if they're still trying to. If something is like 40 or 50 years down the road, I think it's a completely different thing. If no one's made a nickel off something for decades, I don't really think it has the same urgency and claim that people around the table have kind of think. So I think things like that would be, and I don't think they should be mandatory, but they, by putting them in there, you could say they could take those things into consideration. I think that would be helpful. I'd point out a few other things from the patent side. TRIPS also. TRIPS allows you to eliminate injunctions altogether in Article 44.2 in cases where you provide either adequate or reasonable compensation in different ways. The U.S. has done this as it relates to federal government use of copyright and patented works through 28 U.S.C. 1498, where there is no injunctive relief available and everything's sort of handled that way. We also done it more recently in the Affordable Care Act, where an infringement of a patent on a biologic drug is limited there's no injunctions available if it's not disclosed. It's sort of similar to the orphan works. If you do not disclose the patents to the generic maker of the biologic drug in a timely fashion, you cannot get an injunction. That's just taken off the table. And then they have two different standards for compensation. One's reasonable, the other one's nothing if you're really late. So they have kind of a graduated response, taking away your rights to enforcement depending on how undiligent you are in pursuing it. And I think that pursues kind of an interesting model for this. So I kind of like the idea of the worse you are about pursuing your rights, the fewer rights you have. I mean, your first opportunity is a person has to approach you. If you don't disclose then you lose some rights, and if you continue to be a bad actor, you lose more.
Thank you, Mr. Love. I'm going to move along because we have a lot of other people who wanted to make a point. And at this point, I also wanted to check in about the small claims issue because people had talked about the importance of the formalities and how hard it is to go to court. We at the Copyright Office totally agree that there's a very large burden on going to federal court. And I'm not sure how familiar everyone is with their small claims report, but one of the aspects of it was that we took the position that it would be an application at the time of bringing the suit within the small claims tribunal, so versus our normal position that you should have a registration before going to court, which obviously is a position of a circuit court split, but something that would make it a little bit easier for an orphan work owner who we assume would be more of a small entity versus a large entity, although who knows, it could be both. With that in mind, I think I have Ms. Kogan, Mr. Weinberg, Mr. Osterreicher, and then Mr. Katz. And if we have time, and then, actually, let me give the floor to Ms. Feltrin, who has not had the opportunity to speak first, and then I will move on.
Okay, thanks very much. I just wanted to bring it back to a point earlier that Mr. Cram made, and also in the context of the roundtables in terms of mass digitization, because I think that a lot of the issues that we're discussing today, at least some of them were also brought up in the 2005-2006 discussions, but not so much on the issues of mass digitization. So I just thought Mr. Cram made some very important points in the context of libraries, because mass digitization projects are going on and the costs, potentially costs are huge. So I just wanted to also support the notion of non-commercial actors engaging in non-commercial uses. For libraries, I think that would be very important, particularly with mass digitization projects.
Thank you, Ms. Feltrin, and we will have our next panel on mass digitization, and we have a couple on extended collective licensing for those who are interested in it. So Ms. Kogan, and I apologize, but I'm going to ask people to be a little more brief because we are running out of time, but if you could.
So another real-world example where injunctive relief might not be ideal, and this again is in a nonprofit context. This is making sounds. We digitize periodicals. There are some wonderful journals that are defunct. We've searched out, we found editors. They don't seem to think it's owned by anyone. We would like to digitize. Why is this doing this? We'd like to digitize these, and at times we have. It's a pretty big investment because this isn't a one-off document. This is a run of a journal. So in that case, injunctive relief. Okay, in that case, injunctive relief might be less than ideal because we've invested a lot of time. We have sought out editors, others. We've done what we would consider a diligent search. We do compensate publishers, and we would be happy to compensate that publisher like we do others for the right to use the content.
Thank you, Ms. Kogan, and I think I'm going to call on Mr. Osterreicher next, and before I do, I wanted to point out something that was raised in our small claims roundtables that I think some of you were at, which was that sometimes going to federal court is just out of the question if it costs $50,000 to litigate in federal court to try to get a couple of $100s in royalties or reasonable compensation. So if you wanted to touch on that as well in your comments, that would be nice.
I think the practicalities here are that when someone who's created a work realizes that it's being used or misappropriated in some way, I mean, we've heard the parade of horribles, the $1.8 billion cost. I mean, normally, and I advise at least all of our members that if you found that somebody's infringed on your work, don't think you've won the lottery. I mean, you need to, obviously, everybody needs to be reasonable on both sides. And the first approach is not to go to court. It's to either make a phone call or send a letter and say, hi, I'm so-and-so, and this is my work, and I believe you've used it, and let's talk about it. Now, there are some people that say, gee, we're sorry, let's talk about it, and they have a meeting of the minds, and we're done. There are other people that assert fair use and believe that fair use is something that they can rely on. I've unfortunately found that it's the FU defense. That's what it's become. And it's something that people just assert and go on their way rather than, well, wait a minute, that's for the court to decide down the road. So do you want to go there? That's something to think about. So what we're trying to figure out here is when everything else has failed, rather than dealing fairly with one another, where do we go in this whole scheme of things? And that's, I think, something we need to realize here in terms of keeping that reasonableness in mind, whether it's reasonable compensation. I think all of this can be avoided when somebody realizes that they have used the work inadvertently. They've done the best they could. I mean, Hattie Trust is a perfect example. Okay, we thought we were doing the right thing, but we're not. So how do we fix it? Well, in that case, they stopped doing it. In another case, when they found out somebody's using a work, okay, let's let's compensate you fairly and go on from here. So I think that's something that's really important to keep in mind. We're like looking at worst-case situations rather than what we could do at the beginning to avoid all of this.
And I think we talked about earlier, I'm not sure if it was you or someone else at the table, who mentioned perhaps taking advantage of Orphan Works legislation or limitations to having to go to a small claims tribunal if it was created. How do you feel about that?
Absolutely. I mean, I think that that's part of it. If you then are going to assert an Orphan Works defense, in other words, in order to participate in that and avail yourself of it, on the other side of the coin, you're going to have to then be willing to buy into adjudicating this in a small claims venue.
Thank you. And the reason I bring that up for those who are not that familiar with the small claims issue is that there are many constitutional protections that we need to make sure that we pay attention to and give due consideration to that make it very difficult to try to make it mandatory small claims court. So I think we have time for maybe one or two very brief comments. I have Mr. Weinberg and Mr. Burgess and Mr. Boyle. If you could leave it very, very briefly, that would be nice. So Mr. Weinberg.
First, I just want to remind, when you're thinking about injunctions and their role, I mean, these remedies are not punishments. If you did something actually wrong, you're probably going to be outside the scope of Orphan Works. And so especially in the context of copyright, we're talking about disseminating information. I don't want to rule out injunctions, but I think they should be used especially warily, especially in these commercial contexts where there often is a number that can remedy the solution in terms of a monetary penalty. Quickly, I think that it's problematic if we call the registration system broken, but then propose the solution for Orphan Works a registration system on people who want to make use of Orphan Works. Just conceptually, I have some problems with that I won't go into for time purposes. The small claims court, I think, is an interesting idea, making it mandatory for Orphan Works. I do have concerns about those protections and whether or not small claims is kind of a one-size-fits-all for all Orphan Works systems. And then finally, I feel like it's my role as a public interest person to say that while sometimes people do assert fair use in problematic ways, I don't know that it's always the FU defense. And I think that it points to the role of education and the great best practices guide that some of my colleagues have put together at American University to help educate people about the proper role of fair use, because I suspect that in many cases, fair use is a legitimate response to those complaints.
Thank you. And Mr. Burgess, for some brief comments.
Yeah, two things quickly. One is, I know our members are somewhat sensitive to the idea of not-for-profit institutions, and it may be possible to, have some exceptions in that area, but they would need to be extremely narrowly defined. And then the second thing is, with respect to Mr. Love's comment, with this declining, remedy based on how quickly you act. That is an impossible situation for a small business or for an independent. And very often you don't even know these usages have happened. It takes you years sometimes to find out, and it's often pure luck that you actually do find out. So the idea that there should be any time out on your remedy would not be acceptable to us.
Thank you, Mr. Burgess. And Mr. Boyle, you get the last word very briefly.
Also really quick, in regards to fair use, we also think it's important to differentiate between large-scale digitization efforts and case-by-case uses. We have fair use rights that are used, but they don't cover all uses, especially when people want a license. And we believe limiting liability will encourage licensing.
Thank you, Mr. Boyle. At this point, I think that concludes our panel. We're not going to have time, I think, to do our audience participation questions, but I would like to point out that we are having an entire session at 4 o'clock today in the hearing room for anyone who has things that they want to say, both from the audience and from the panelists, after the audience members have their opportunity.
This has been a presentation of the Library of Congress. Visit us at loc.gov.